No, he's muted.
Is Roderick Davis around?
He's in the jail, Judge.
All right. I guess he's around.
Hopefully.
Yes, he's here. Do y'all need him?
We can, yes, sir.
Okay.
Okay. We got everybody here present.
Well, we don't have the state, but I'm okay with that.
Oh, well, that probably needs. Oh, it's not even 9 yet. I'm trying to depart the gate before departure. Is Davis a straight probation?
No, Your Honor. State jail time.
Okay. I was getting that mixed up. I tried to write everything down and. So how's your new assistant working out?
My son?
No, your new administrator.
Yeah, no, I don't even think of her as new because she's been here for longer than I have. She's doing great in Sharon's old position.
Well, that's good.
Yeah, she's been very well trained. She's got the experience. I love it when things work so smoothly. I don't even notice it. So.
Well, I'm glad that she'll be good.
Yeah. I'm happy she got the pay raise too.
And are you going to have to, I guess you'll have to hire someone else now, unless you've already done that.
Well, yeah, I've had that conversation with Connie. We are on a hiring freeze until the police start issuing more citation. The court has a little more business. So.
Oh.
Yeah, which is out of my control because, I can't, they're not going to give me a badge and let me go issue tickets to people. So. But
well,
I talked to the police chief about it. He said they're about to get back to normal operations instead of what they were doing during COVID. So.
Well, I'll let my grass grow high and I'll start speeding if that'll help.
I'll be very harsh on you, Judge. So.
No. Have you been using your rescue inhaler? No.
Good morning.
Morning.
That sounded so positive there, Cody.
I mean,
It's a morning.
yeah, I'm awake. I'm alive.
Okay, well, let's get started. We will go on the record in D40236-CR State versus Roderick. Davis, I have counsel for both sides present, defendants present. Mr. Davis, is that your full and complete name?
Yes, Roderick Renee Davis. Yes, sir.
All right, sir. And you're charged with theft of property under 2,500 with 2 or more previous convictions. Is that correct?
Yes, Your Honor.
And the court understands you're wishing to enter a plea of guilty to that offense in addition to the prior convictions, pleading true. Is that correct?
Yes, Your Honor.
All right, and you do understand what you're pleading guilty to?
Yes, sir.
All right, Mr. Beecham, do you wish to waive a reading of the indictment?
Yes, Your Honor.
Record can so reflect. Mr. Davis, I have documents in this case that appear to have your signature on them. They are written waivers, written plea admonishments, a waiver of your right of appeal, a judicial confession, and an evidence discovery log. Did you sign these documents?
Yes, I did.
And did your attorney go over these documents with you?
Yes, he did.
Did you understand everything you signed, sir?
Yes, Your Honor.
Now, Mr. Davis, you understand you have a right to have a jury trial in this case, and you're waiving that right.
Yes, Your Honor.
Also, sir, if you were found guilty, you would have a right to have that same jury assessed punishment. Do you understand that?
Yes, Your Honor.
Are you a citizen of the United States?
Yes, sir.
This is a state jail felony, sir. It carries a range of punishment anywhere from 180 days up to 2 years in state jail and a fine not to exceed $10,000. You understand the range?
Yes, sir.
And it's the court's understanding that you've entered into a plea agreement with the state through your attorney. Is that correct?
Yes, sir.
Now, the court will not agree to be bound by the plea agreement you've entered into. However, if the court follows the plea agreement, it does cut off your right of appeal except by permission of the court. Do you understand that?
Yes, sir.
Are you entering your plea of guilty freely and voluntarily?
Yes, Your Honor.
You understand the consequences of your plea of guilty?
Yes, sir.
Your attorney is Mr. Beecham. He's present here with you. Are you satisfied with his representation, sir?
Very much.
And Mr. Beecham, your client certainly appears to be sane and mentally competent. Is there anything that your client has said or done that would cause you to believe otherwise?
No, Your Honor.
Court this time will find the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered his plea of guilty, that he understands the consequences of his plea of guilty. The court will accept that plea of guilty and find the defendant guilty should the evidence prove him guilty. I have in front of me states 1, a judicial confession signed by the defendant. State seeking to have that exhibit admitted.
Yes, Your Honor.
No objection.
It'll be admitted. Anything further from either side?
No, Your Honor.
No, Your Honor.
State have a recommendation.
Yes, Your Honor. Upon a finding of true of the previous ones and guilty on this offense, the state's recommendation is 12 months TVCJ state jail, $210 fine, $290 court cost, and 212 days time credit served.
And Mr. Beecham, is that you and your client's understanding?
Yes, Your Honor.
All right. Sir, based on the evidence, the court will find you guilty of the offense, find the enhancements to be true. The court this time, having found you guilty, will sentence you to 12 months in a state jail facility with a fine and court costs to be assessed. Any reason why sentence should not be pronounced?
Your Honor, forgive me, it's been a while since I've done a state jail in your court. Judge Putman usually finds defendants presumptively eligible for.
Yes, I'll do that here momentarily.
That was my only other concern. Other than that, we're good, Judge.
Okay. All right, sir, you are sentenced to 12 months in a state jail facility. You are remanded to the custody of sheriff who will transport you to the appropriate facility, begin serving out the sentence. This sentence begins today. You are given credit on the sentence of 212 days, and any day thereafter, the court will make a finding. At this time, you are presumptively entitled to receive diligent participation credit if and when that's received by the court. Do you understand that?
Yes, sir.
Mr. Davis, that diligent participation credit comes directly from state jail to the court. I believe it is all computer generated. because anytime I receive one, it comes at 4 o'clock in the morning. Exactly. So do what you got to do to be involved in that program, but don't send me letters saying you've participated, because I cannot act on your letters. It has to come from state jail. Okay.
I understand.
We've
All right.
discussed it at length, Your Honor. I anticipate he's going to be a model prisoner. So
Okay. All right, sir. Do you have any other cases pending?
I don't believe so. You know,
Okay.
I may have something in Dallas County, I believe.
Okay.
I'm really sure.
But here in Navarro County, you're
Yeah.
cleared as of now. Okay. All right, sir. In this case, you've waived your right of appeal. That concludes this hearing. You will receive, the bailiff will come over here shortly and get your prints on the judgment and on the docket sheet, okay?
Okay. Thank
All
you.
right, sir. Good luck to you.
good luck to you, Your Honor.
Bye-bye.
Can I be excused, Judge?
Yes, sir. Have a good day.
You too.
Tyrell Leonard. Okay, we'll go on the record in D40739 and D40741, both style state versus Tyrell Leonard. Counsel for both sides is present, defendants present. These were motions to withdraw, and I think I recall this case, and I think there was a motion withdraw by another attorney in his other cases. So, Mr. Perkins, you may proceed on your motions to withdraw.
Thank you, Judge.
Having a hard time
I
here.
have met with Mr. Leonard a couple. Judge, hang on just one sec. You've caught me about 5 minutes from the office. Let me pull over and see if you can hear me a little better.
Okay. Probably be better for everybody.
Yes, Judge.
Say something. Well, say something. Who? Me? Me? No.
Okay, is that better, Judge?
Yes, sir.
Okay. Judge, I've attempted to meet with Mr. Leonard a couple of times, attempted to go over the discovery with him. I have, for whatever reason, I cannot communicate with him. He doesn't want to hear anything I have to say. He's combative. So I can't effectively communicate it with him. I have much of the same issues that Miss Martin was having with him. The relationship now is deteriorated to where there's no way that I can, effectively represent him at this point. I think he would be in agreement with that statement, and that's why I filed the motion to withdraw.
So what we have here is a failure to communicate, sounds like?
Yeah, an inability to communicate.
Okay. That was a great line from that movie, but and it's applicable today.
I missed the reference, Judge, but yes, that is a great line from that movie.
Yes. Well, and I believe, if I recall correctly, Mr. Leonard, in the other case with your other attorney, was it my understanding you were going to hire counsel, sir?
Oh, yes, sir. I had I requested for another lawyer.
Okay.
I believe he said he was going to hire Neil Green, Judge.
Yeah, that's kind of what I recall. But anyway, all right. Well, state have any opposition, any objections to the motions to withdraw?
State has no objections, Your Honor. Just understanding that Mr. Leonard, if he's getting a court-appointed attorney or if he's incarcerated, someone's going to hire one for him. I'm a little confused on which one.
I had put in a request for a court-appointed lawyer right now.
Okay. All right.
Yeah,
We're going to get one attorney for all 4 of his cases.
I think we have the indigent defense coordinator here. Hopefully that will occur.
Thank you, Your Honor.
All right, motions to withdraw are granted. I'll sign those orders. If I have them in front of me, I'll sign them. If not, I'll sign them in e-file. I don't see a proposed order, but if Mr. Perkins, if you get those to me.
I sure will. Thank you, Judge.
All right, that concludes.
Best of luck to you, Mr. Leonard. Thank you, Judge.
Thank you. Have a good day. Mr. Coffey?
Judge, can I just say something to my client real quick? It's not private communication, so I can just
Yeah,
explain.
that's fine.
Mr. Coffey, so we had talked about how, you're going to get adjudicated on this offense, but I want to be clear. This is not going to be a felony conviction. It's going to be just a misdemeanor. Okay. You'll still be on probation, but it's going to be a misdemeanor. Okay. So it's good news, but just want to make sure you understand.
Very good. Thank you.
Okay, we'll go on the record in cause number D38716-CR State versus David Brian Coffey. I have counsel for both sides present. Defendant is present. Mr. Coffey, oh, Lee, my head is really big. It's really close to this. That's better now. Mr. Coffey, you are David Brian Coffey, is that correct?
Yes, sir.
And Mr. Coffey, I just now started thinking of that former Mr. Coffey, the coffee maker. It doesn't take much to entertain me these days. But Mr. Coffey, sorry, I'll get through
This
this.
has probably been a plight he's dealing with his whole life, and you're just
I
making
know,
it worse.
and I'm not helping any. I know.
As a person whose name is Star, I can tell you that I've been traumatized by Twinkle Twinkle Little Star for my entire existence. So,
Okay. Well, I won't. Yeah. Well, now I'm not going to be able to laugh. I'll have to laugh at your name from now on.
I said it to myself. I know.
Mr. Coffey, the court back in 2019 placed you on community supervision. Do you recall that?
Yes, sir.
And sir, the court deferred a finding of guilt for a period of 2 years, ordered that you comply with terms and conditions of probation. Do you recall that?
Yes, sir.
If in my notes here, and I think your attorney's already referenced it, the court at that time placed you on probation, and it was placed under 1244B, making that punishable as a misdemeanor. Do you recall that?
Yes, sir, I do.
All right. Now, since that time, the state has filed a motion to adjudicate, alleging that you violated terms and conditions of probation. Is that correct?
Yes, sir.
And it's the court's understanding, sir, you're wishing to enter a plea of true to those allegations in the motion to adjudicate. Is that correct?
Yes, sir.
Are you doing this freely and voluntarily?
Yes, sir, I am.
And do you understand the consequences of pleading true?
Yes, sir, I do.
All right. Ms. Romer, do you wish to waive a reading of the motion to adjudicate?
Yes, Judge.
All right. Record can so reflect. Mr. Coffey, I do have documents that appear to have your signature on them. They are written waivers and stipulations on revocation and probation. There is a judicial confession and a waiver of your right of appeal. Did you sign these documents?
I'm sorry, do what?
Did you sign the documents I just asked you about?
Yes, sir, I did.
And did your attorney go over these documents with you?
Yes, she did.
Did you understand everything you've signed, sir?
Yes, sir.
All right. Now, you understand that you do have a right to have a contested hearing in this case, and you're waiving that right.
Yes, sir.
All right. Your attorney is Ms. Romer. She was not originally on your case when you pled. It was a different attorney, but as far as Ms. Romer, on this motion to adjudicate, are you satisfied with her representation?
Yes, sir, I am.
Okay. Ms. Romer, your client certainly appears sane and mentally competent. Is there anything that your client has said or done that would cause you to believe otherwise?
No, Judge.
Court this time will find the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered his plea of true, that he understands the consequences of his plea of true. The court will accept that plea of true and take appropriate action based on the evidence. I have in front of me states one, a judicial confession signed by the defendant. States he can have that exhibit admitted.
Yes, Your Honor.
No
Any-
objection.
It's admitted. Anything further from either side?
No, Your Honor.
No, Your Honor.
State have a recommendation?
Yes, Your Honor. State's recommendation upon a finding of true is it's 180 days over 2 years probation. The remaining of the $750 fine, the remainder of the $344 court costs, the remainder of the 150 hours of community service, hair strand test, ADAC, DOEP, $180 DPS crime lab, court-appointed attorney fees, and the $855 delinquent probation fees on top of the probation fees that he will be required to pay
Okay.
now that
And
he's on
Ms.
regular probation.
And Ms. Romer, is that you and your client's understanding?
Yes, Judge, and I would ask that you waive the court-appointed attorney's fees.
Okay. I'll consider that. Based on the evidence, the court at this time will grant the state's motion to adjudicate. The court will find Mr. Coffey you guilty of the offense alleged in the indictment. It is the judgment of the court that you're sentenced to 180 days in the county jail. However, imposition of sentence will be suspended for a period of 2 years where you're ordered to comply with all terms and conditions of probation. Mr. Coffey, do you have a job lined up when you get out?
Yes, Judge, I do. I actually spoke to my boss a few days ago, and as soon as I'm out, I can go right back to work.
Where do you work, sir?
I work for a man named James Stow, doing floors and tiling showers and stuff like that.
Okay. All right. Well, I don't think there's any shortage of construction, and whether it's new or remodels going on. So hopefully that will keep you busy for the foreseeable future.
Yes, sir.
I think Ms. Romer, I know you asked that the court waive, but I will order he can pay the attorney's fees. Mr. Coffey, you will be released here shortly. Assuming you have no holds out of other counties or jurisdictions. And I bet you will need to go see someone in probation. Who is your officer?
It was Officer Janie Stevens.
Okay. All right. Well, I have Ms. Ramos on here, and in a second, I'm going to let her give you some directions on what to do, okay?
Okay, thank you, Judge.
In this case, sir, you have waived your right of appeal. That concludes this hearing. Bailiff will come over here and get a print from you, sir, on the judgment and on the docket sheet, okay? And then
Thank you.
you should be discharged, but Ms. Ramos is here. She's going to give you some directions, okay?
Okay, thank you, Judge.
Thank you. Good luck to you, sir.
Thank you.
Okay, Mr. Coffey, would you come and report as soon as you get out of there to the
Yes, I
probation
will.
department and
Yes.
talk with Janie about it?
Okay, no problem.
Okay. Okay, I'll
All right,
see you
sir.
then.
Good luck to you.
Thank you.
My bailiff will be over there shortly, sir. She flies over there with her butterfly wings, and she'll be there shortly. Joseph Buchanan. Ms. Romer, have a good, she's already disappeared. All right, we will go on the record in D41034, State versus Joseph Michael Buchanan, and I have counsel for both sides present, defendants present. Mr. Buchanan, is that your full and complete name?
Yes, sir.
And Mr. Buchanan, you are charged with the offense of assault on a family member by impeding breath or circulation. Is that your understanding of what you're charged with.
Yes, sir.
Now, it's the court's understanding that this case has not been presented to a grand jury. Is that your understanding?
Yes, sir.
All right, and the court understands you're wishing to waive your right to have a grand jury review this case and proceed on what's been filed with this court in an information. Is this true?
Yes, sir.
All right, now you understand the grand jury, sir, could go ahead and review this case, decide to indict you. They could decide to send the case back for additional information or investigation, or they could decide to no bill you. You understand that?
Yes, sir.
Knowing that you wish to proceed on what's been filed, again, with this court and information.
If I may, Your Honor,
Yes,
this case was actually indicted on Thursday with the last grand jury last Thursday. We do have a cause number on it, but I just want to make for sure because at the time that it was filed, it was by information. Since then, the grand jury hasn't done.
oh, I don't have the, let me recess for 1 second. I don't have the indictment in front of me.
Okay.
So would it have a new, different cause number then?
No, I don't believe so, but we can.
Let me, give me 1 sec. I want to make sure.
Okay.
Miss Beatty, have you seen the indictment?
No, I was actually told by the district clerk's office that it was not on the grand jury list last Thursday, and therefore it was filed by information this week, which is why we have the cause number.
Give me one moment, Your Honor. Let me see if I can find the indictment.
Okay.
I'll see if it was signed by them. And I do apologize, Your Honor. The grand jury did not sign this one. It was held back.
Okay. All right. Well, now we know. Okay. We'll come out of recess and so Miss Beatty, do you wish to let's see. I'm trying to think where we were. Okay, sorry. So you're saying charged by information, and Miss Beatty, do you wish to waive a reading of the information, arraignment in 10 days?
Yes, Your Honor.
Record conservative flag. All right, Mr. Buchanan, I do have documents that appear to have your signature on them. I've reviewed them earlier. They are written waivers and written plea admonishments and a waiver of your right of appeal, as well as a judicial confession and an evidence discovery log. Did you sign these documents?
Yes, sir.
And did your attorney, sir, go over these documents with you?
Yes, sir.
Did you understand everything you signed, sir?
Yes, sir.
Now, you understand, sir, that you have a right in this case to have a jury trial, and you're waiving that right.
Yes, sir.
And you understand you also have a right to have the same jury assessed punishment should you have been found guilty.
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
This is a third-degree felony. It carries a range of punishment anywhere from 2 to 10 years in the Texas Department of Criminal Justice Institutional Division, and a fine not to exceed $10,000. You understand the range?
Yes, sir.
And it's the court's understanding that you have entered into a plea agreement with the state through your attorney. Is that correct?
Yes, sir.
Now, the court will not agree to be bound by the plea agreement. However, the court follows the plea agreement. It does cut off your right of appeal except by permission of the court. You understand that?
Yes, sir.
Are you entering your plea of guilty freely and voluntarily?
Yes, sir.
Do you understand the consequences of pleading guilty?
Yes, sir.
Your attorney is Miss Beatty. Are you satisfied with her representation, sir?
Yes, sir.
Miss Beatty, your client certainly appears to be sane and mentally competent. Is there anything your client has said or done that would cause you to believe otherwise?
No, Your Honor.
Court at this time will find that the defendant is sane and mentally competent. Court will find that he has freely and voluntarily entered his plea of guilty, that he understands the consequences of his plea of guilty. The court will accept that plea of guilty and find the defendant guilty should the evidence prove him guilty. I have in front of me states 1, a judicial confession signed by the defendant. States he can have that exhibit admitted.
Yes, Your Honor.
No objection?
It's admitted. Anything further from either side?
No, Your
Nothing
Honor.
from defense.
They have a recommendation.
Yes, Your Honor. upon a plea of guilty to the current offense of assault, family violence, impeding breast circulation, and true to the enhancements, the state's recommendation is 5 years TDC, probated for 7 years, $1,000 fine, $290 court costs, reimburse the county for the court-appointed attorney, restitution of $3,655 payable to Navarro County Hospital for the injury sustained by Ms. Connie Holt. Community service restitution of 200 hours. Defendant must take a hair strand test every 90 days. No violent contact with Connie Holt. Anger management, BIPP.
Ms. Schumer, before I turn over to Ms. Beatty, you said no what type of contact? With
No violent contact.
Violent, okay, that's what I thought I heard. Ms. Beatty, is that you and your client's understanding?
Yes, with the exception, Judge, that there aren't any enhancements on the information.
Yeah, that's what I was wondering.
Let me look.
I think I saw, we can go off the record. I think I saw something about an enhancement on the proposed judgment, but I maybe I'm getting it mixed up with something else. Yeah, there's nothing on the information that reflects a.
Then, Your Honor, we may need to reset this because there is an enhancement that brings it to the charge that it is.
No. So as it is, it's a third degree. Assault, family violence, impeding breath, that is a third degree. And so that's what all the paperwork reflects, is that it's a third degree.
Yeah, that's what the information showing is. It's a third. I mean yeah, I mean it's a third degree because of the
Okay,
Impeding breath.
offense.
that's fine, Your Honor.
So
I just
But
wanted
if-
to make for sure we weren't going to do a state jail felony. We're, making it worse without the enhancement,
No, it's
Well,
a third degree.
if I may need to get that judgment back and just strike through. If that's the one I remember, if there's an enhancement, I probably need to strike through that. I can just do that on an e-file. I mean, yeah.
Do you want us to refile it, Your Honor, or you just scratch through it?
I will just scratch through it. There's no reason to do a new one.
Thank you, Your Honor.
Okay. We'll come out of recess. And so, Ms. Beatty, now that you've had an opportunity, I think you brought to everyone's attention, this is a third degree felony and there's no enhancement. And is that you and your client's understanding of the recommendation?
Yes, Your Honor.
Okay. At this time, then, the court will find Mr. Buchanan guilty of the offense alleged in the indictment. I'm sorry, in the information. It's the judgment of the court that he is sentenced to 5 years in the Texas Department of Criminal Justice Institutional Division. However, imposition of sentence will be suspended for a period of 7 years. During the 7-year period, sir, you are ordered to comply with terms and conditions of probation. Do you understand that?
Yes, sir.
Mr. Buchanan, do you live here in Navarro County?
No, sir.
Where do you live, sir?
I live in Las Vegas, Nevada.
Okay. I'm assuming that's where you're going to go when you're discharged?
Yes, sir. If
Okay.
I'm allowed.
I don't see any reason why you wouldn't be, but there is a process, and it's good we're doing it this morning because there is a process that takes some time, but I don't.
Yes, I understand that I'll probably have to do an interstate compact and get it transferred up there, and that might take some time. So I am from here, so I do have family here that I could stay with in the meantime.
Okay, sounds good. My next question then to you, sir, is do you read and write the English language?
Yes, sir.
Make sure you read through the order I've just signed. It tells you what you can and cannot do, okay? And orders what you need to be doing, all right?
Yes, sir.
All right, sir. And short of that, do you have any other cases holding you in the county jail?
Yes, sir. I have a misdemeanor.
Okay,
He set tomorrow on the misdemeanor to plea, Judge.
okay. So I don't know if you bond out on that between now and tomorrow, sir, or if you're just going to remain in jail till you take care of that. Either way, we will. Either way, you'll need to report to probation. Okay.
Yes, sir.
whether that's today or tomorrow when and I don't know what your sentence will be or your recommendation in the misdemeanor case, but let me just cut to the chase. Once you're released, sir, you'll need to report to probation for an intake, okay?
Yes, sir.
All right. I will give you your notice of judicial clemency will be sent over with the bailiff. She'll come get your prints here in a moment, sir. And in this case, you have waived your right of appeal. That concludes this hearing. Ms. Ramos is probably going to give you some directions here in a second.
Well, all I need to tell him is when he gets out, that he needs to report to the probation office. You know where the probation office is at, right?
No, ma'am.
You don't know where the probation office? Well, the jail will give you a piece of paper that will tell you the directions to the probation office.
Yes, ma'am.
Okay.
All right, sir. Good luck to you.
Thank you, sir.
All right. I think that's it for the jail. We just have one more to go. Mr. Shields.
He is in jail, Your Honor.
May I be excused, Judge?
He is in jail. Oh, okay. Yes. Have a good day.
You too.
Probation's on the backside. With you, instructions. Morning, Judge. Yeah. Don't get too comfortable. Call you back up. You comfortable.
All right. Okay, we will go on the record in cause number D40957, State versus Kenneth Ray Shields. I have counsel for both sides present, defendants present. And Mr. Shields, is that your full and complete name?
Yes, sir.
And Mr. Shields, it's the court's understanding that you're wishing to enter a plea of guilty to the offense alleged in the indictment, that being possession of controlled substance, penalty group 1, greater than 1 gram, less than 4 grams. Is that correct?
Yes, sir.
And do you understand, sir, what you're pleading guilty to?
Yes, sir.
All right. Has Mr. Shields been arraigned yet?
No, Your Honor, I believe that was scheduled for the 17th, so we'll waive arraignment in 10 days.
Thank you. Record and so reflect. Mr. Shields, I do have documents that appear to have your signature on them. They are written waivers and written plea admonishments, a waiver of your right of appeal, judicial confession, and an evidence discovery log. Did you sign these documents?
Yes, sir.
Did you understand, sir, everything that you've signed?
Yes, sir.
Your attorney went over these documents with you. Is that correct?
Yes, sir.
You understand, sir, that you have a right to have a jury trial and you're waiving that right.
Yes, sir.
You understand you also have a right to have the same jury assess punishment should you have been found guilty.
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Now, this is a state jail felony, sir. I'm sorry, it's a 3rd-degree felony. It carries a range of punishment anywhere from 2 to 10 years in the Texas Department of Criminal Justice Institutional Division and a fine not to exceed $10,000. You understand the range?
Yes, sir.
It's the court's understanding that you have worked out a plea agreement with the state through your attorney, Ms. Watkins. Is that correct?
Yes, sir.
Now, the court will not agree to be bound by the plea agreement. However, if the court follows the plea agreement, it does cut off your right of appeal except by permission of the court. You understand that?
Yes, sir.
Are you entering your plea of guilty freely and voluntarily?
Yes, sir.
And Mr. Shields, do you understand the consequences of pleading guilty here this morning?
Yes, sir.
Your attorney is Ms. Watkins. Are you satisfied with her representation in this case?
Yes, sir.
And Ms. Watkins, your client certainly appears to be sane and mentally competent. Is there anything that your client has said or done that would cause you to believe otherwise?
No, Your Honor.
Court this time will find the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered his plea of guilty, that he understands the consequences of his plea of guilty. The court will accept that plea of guilty and find the defendant guilty should the evidence prove him guilty. I have in front of me states 1, a judicial confession signed by the defendant. Is the state seeking to have this exhibit admitted?
Yes, Your Honor.
No objection.
It's admitted. Anything further from either side?
No, Your Honor.
No, Your Honor.
State have recommendation?
Yes, the state's recommendation upon a finding of guilt. 4 years TDCJ, suspended for 6 years, $410 fine, $290 court cost, $180 to the Texas DPS Crime Lab, 120 hours community service, must successfully complete and be discharged by the Adult Challenge of Dallas. If he is not accepted or if he leaves the facility before he successfully completes the program, the defendant will be ordered to Safe P. Once he has completed that, at probation's advice, there will be an alcohol and drug assessment, DOEP, weekly AA or NA meetings once he's discharged from either the Adult Challenge or from Safe P, hair strand test every 90 days, and court-appointed attorney fees.
What was the fine amount?
$410.
Ms. Watkins, is that you and your client's understanding of the plea agreement?
With a few exceptions, Your Honor. Number one, I communicated to the district attorney's office that we never received a lab report. I don't think there's a lab report back on that. So we'd ask the court to strike the $180 of restitution since that testing has not been done yet. Also, with regard to court-appointed attorney fees, my client remains indigent and will continue to be indigent. The challenge program is an 18-month program, so he will not have the opportunity to work during that time. So we'd ask the court to waive court-appointed attorney's fees.
Okay. So he'll go from the Navarro County Jail to this Adult Challenge?
No, Your Honor. We would be requesting that he be released today and that he be required to turn himself into that or be accepted into that program within 30 days. My understanding from speaking with the program, and I've talked to Ms. Schumer about it, is that he has to get a physical and some lab work done. The only requirements of the Adult Challenge program are that the lab work shows that he is doesn't have TB or COVID or hepatitis. And so he has to meet those requirements. There are no other, requirements as far as, health wise, but he does have to get a physical to go in and to get that lab work done. So he'll have some time to do that. There is an admission fee of $290 that he and his wife will have to get together to go. But I have received a letter from Adult Challenge that he's kind of presumptively accepted into that, assuming that that those things are met. And so he will need to get out in order to complete that physical and blood work and get himself to that program. So okay. We understand the court is reluctant to do that sometimes, but since we have the fallback of Safe P, if he's not accepted into that program for whatever physical reason, then that will automatically kick in as a condition of his probation.
Okay.
Your Honor, if I may, if he
Yes.
is required to report weekly until he is accepted into that program, I think that'll keep that probability of him not returning or not reporting and not in down to a minimum. So he would be successful on the on this program for helping him do better. Further on the lab results, we can call the lab and ask them if they haven't tested it to not test it. But if they've already tested it, that cost should just be assessed as part of the fines that he could pay over the next 7 years. And we'll send the lab results if they've already tested them to Ms. Watkins.
Okay. Based on the evidence, the court, first of all, will find the defendant guilty of the offense alleged in the indictments. The judgment of the court, he's sentenced to 4 years in the Texas Department of Criminal Justice Institutional Division. However, imposition of sentence will be suspended for a period of 6 years. During the 6-year period, he is ordered to comply with terms and conditions of probation. Restitution amount is, if it's not been done, then if it's not been tested already, then court will not order that be paid. Based on what I understand, Mr. Shields' period of being in this program, I will waive the attorney's fees. Mr. Shields, you will be discharged from the Devere County Jail with the order that you enroll in go through all the requirements that are required to get into the adult challenge program. If that does not occur, if you're not able to get into that program, then you'll need to contact your probation officer and we'll come back for a modification, I guess, with a safe fee. Okay?
Okay. Yes, sir.
Do you live here in Devere County, sir?
Yes, sir.
And so you'll be reported to an officer here. Now, obviously, if you're in this program, it sounds like it's you'll be in a facility, so you'll not be able to report in person as you normally would be able to, but you'll need to keep in contact with your officer, okay?
Okay.
It's my understanding, Judge, from the program that they work with probation and that they will transport if necessary to probation and do whatever they need to do to work with probation. They do that regularly. And I'd like also to say that Mr. Shields seems extremely motivated. He's probably one of the most motivated clients that I've had with regard to treatment. He sought this particular faith-based program out himself, and I believe his wife is very supportive of him getting treatment and getting healthy.
Well, I'm glad to hear that. Mr. Shields, this is all on you, as you probably know. So I wish you all the best, and hopefully you can get the help you need, and maybe you can help influence somebody else down the road that's got the same issues you got.
Thanks.
All right, sir. I believe, do you have anything else holding you in the county jail other than this one case?
Excuse me?
Do you have any other charges pending?
Oh, no, sir. None I know of.
So you should be discharged then as soon as we're done with this hearing. They can go ahead and book you out. The bailiff will come over here shortly and get your prints on the judgment and on the docket sheet, and your notice of judicial clemency will also be a copy will be sent with her to you. Okay.
Okay.
All right,
Thank you,
sir.
Judge.
Yeah. Well, you're welcome. And you've waived your right of appeal, sir. At this time, that concludes this hearing. Ms. Ramos is going to give you some direction. Okay.
Okay. Thank you.
Yes, Mr. Shield, when you come out of the when you come out of the jail, come over to probation so that we can get your general information.
Okay.
And be able to work with you on that program.
Do you know where the probation
my wife will have
department
to
is?
come get me.
Okay.
I'll be on my way.
All right.
Okay.
All right, sir. Good luck.
Okay.
Thank you for everything.
Have a good day, sir. Good luck to you.
All right.
You, Mrs. Watkins.
Thank you, Ms. Shields. Good luck to y'all.
Young man, be
Bye.
excused.
Yes, ma'am. Y'all have a good day.
You too.
Bye.
Bye.
Hey, Judge.
Uh-huh.
Quick question on Mr. Sullivan. Are you still working on him, or has his file fallen behind your desk?
No. I sent y'all a letter the other day saying I'm ready to do it. Just contact for a setting.
I didn't know we needed another setting. I thought you were just going to issue a ruling.
Well, I thought I needed to do it on the record though.
Oh, okay.
So
Can we get a setting on that then, Melissa? Is she there?
Yes, I talked to him before he went on the bench.
Oh,
I'm just gonna
okay.
Email y'all a date.
What?
I'm gonna email y'all a date.
Okay, that sounds good.
okay.
All right, thank you.
Y'all have a good day.
You too. Bye-bye.